looking to participate. I think we're going to get started and let others straggle in as they will. I have the pleasure now of introducing Darcy Hiltz, who has been practicing since 1983 for more years than either he or I care to think about. Darcy, in the early days of my own involvement in the mental health field, there simply were not very many counsel acting genuinely and vigorously representing people before the review board, and this is a theme that we'll come back to in our next panel. And one of the few people who clearly who set the standard in a way for the vigorous and thorough representation of people before the review board was Darcy Hiltz. And I suppose that's really the introduction that he needs and deserves, and it's just a pleasure and an honor to have him here today. Please join me in welcoming him.
Thank you, Arthur. I'm going to be speaking to you this afternoon about some of the applications that can be made to the Consent and Capacity Board and how these applications are useful in resolving issues which you're going to be coming across, and how these applications offer what I believe to be a preferable alternative to judicial proceedings. Perhaps by a show of hands, you can indicate if you have participated in a Consent and Capacity Board hearing. Okay, thank you. Roughly, I would say for those who aren't here, roughly half. Let me tell you about some of the benefits of applying to the Consent and Capacity Board if you're not already familiar with them. And this is in contrast to judicial proceedings. Number one is cost. There's no application fee to apply to the Consent and Capacity Board. Number two, it's a relatively simple procedure. You fill out an application and you fax it to the board. Doesn't get much easier than that. And who serves your application? Who serves the notice to you? No, the board does all that work for you. So it's a very simple, easy procedure. Another great benefit is a quick resolution to the issue which you have in dispute. The law requires the board to commence the hearing of the application within 7 days from the day it receives the application. The law also requires the board to render a decision within 1 day after the hearing ends. So you've got a decision within 8 days. You've had your hearing and you've got a decision. So certainly something which the courts can't accomplish, but which this board does accomplish. Another benefit as opposed to the court is that you receive the benefit of an expert tribunal. This is a tribunal that is accustomed to dealing with the issue which you're going to bring before it. It's not unaccustomed to it. It hears issues of that nature on a daily basis. Another benefit, obviously, is that it's less formal than the court. One of the things I always liked about representing individuals before the Consent and Capacity Board and practicing in this area, when I first started, I was practicing in criminal law, and I had to justify to my clients the time I was spending in terms of a billing to them outside in the hallway doing absolutely nothing, waiting to be heard. With the Consent and Capacity Board, chances are you're going to be heard on a specific day and a specific time. You're not going to hopefully do too much time waiting around. When you go to court, you spend a lot of time sitting out in the hallway waiting for your case to be called. Maybe it's not going to be called that day. Who knows? So those are some of the benefits. And of course, another benefit is if you disagree with the decision of the board, you can appeal it. So given those benefits, what type of applications can you get before the board which otherwise might lead you to go to the court? Well, how many applications can you make to the board under the three pieces of legislation, the Substitute Decisions Act, the Mental Health Act, and the Healthcare Consent Act? I did a rough calculation, and there are 30 applications which can be made to the board under those three pieces of legislation. However, only one is under the Substitute Decisions Act, 7 are under the Mental Health Act, the remaining 22, or roughly 75%, are under the Healthcare Consent Act. So what I'm going to be doing this afternoon is talking to you about those 22 applications, or at least some of them, that can be made under the Healthcare Consent Act. Keep in mind, when I'm speaking about the Healthcare Consent Act, the three areas of capacity which the Healthcare Consent Act governs. We're going to be discussing roughly 4 case scenarios. If I'm discussing treatment, you can interchange the words admission to a care facility, i.e. a nursing home, and you can also interchange the words personal assistance services, because those are the 3 areas of capacity which the Healthcare Consent Act governs: treatment, admission to a long-term care facility, i.e. a nursing home for our purposes, and personal assistance services. And as you've heard, personal assistance services are those services which are received by residents in nursing homes, essentially. As I've indicated, we're going to discuss 4 case scenarios. It's important to keep in mind 2 principles of law under the Healthcare Consent Act if you're going to be able to appreciate the creative use of applications under the Healthcare Consent Act. Those 2 principles are set out in Section 20 and Section 21 of the Healthcare Consent Act. If you don't have a fundamental basic understanding of those principles, this isn't going to help you. You're going to get lost in this presentation. So roughly review Section 20. 20 sets out the hierarchy of substitute decision makers. Highest ranking substitute decision maker is a court-appointed guardian of the person. Next highest ranking, personal attorney for personal care. Next highest ranking, and this is the key to this presentation, is a board-appointed representative. Third highest ranking substitute decision maker. Takes priority over the next highest ranking, which is spouse or partner. Next highest ranking is child or parent. Next highest ranking is a parent with only a right of access. Next highest ranking, siblings of the incapable person, followed by any other relative. The substitute decision maker of last resort is, of course, the public guardian and trustee. So that's the hierarchy of substitute decision makers. You have to understand that principle. You have to understand that hierarchy. The other principle you have to understand is set out in Section 21, which you heard about earlier. The principles that apply to a substitute decision maker in making a decision for an incapable person. And essentially there are 2. The substitute decision maker must comply with prior capable wishes applicable to the circumstances if those wishes are known, or if those wishes are not known, or if the wishes are impossible to comply with, then the law says that the substitute decision maker must act in the best interests of the incapable person, and best interest, the criteria, is set out in the Healthcare Consent Act. So those are the principles. So we've got 4 scenarios which we're going to go through. We're going to change the facts slightly in each scenario, but let's look at the first scenario. The first scenario is there's an elderly widow in a coma. She's been assessed not capable of a treatment that her health practitioner is proposing for her. She has 3 children. She has no guardian of personal care appointed by the court, and she has no power of attorney for personal care. Her 2 eldest children consent to the treatment. Her 1 youngest child refuses to consent to the treatment. The question, of course, is what happens in such a scenario? Can the health practitioner administer the treatment, given that he's the consent of the majority of the children? Does it make a difference if the majority are the oldest? Would it make a difference if the majority are lawyers and the minority are accountants? I think it would if the majority were 2 accountants You know the old saying, when you put two accountants together, what you get? Two CAs? Caca? In any event, obviously you need consent from all individuals in the same class. The health practitioner can't administer the treatment unless all children agree. And in the event of a failure, the public guardian and trustee will make the decision. The event all children can't agree. But what legal options are available to the children? Well, we all know that any one of the children may apply to the court for guardianship of their mother. And if one of them were to do that, what do you think the other ones would do? They'd probably apply to the court for guardianship as well. I don't know if you've done guardianship proceedings, but I have. They are expensive, they are time-consuming, they are paper-intensive, and they do not offer the benefits which I've discussed earlier about proceeding before the Consent and Capacity Board. So in this type of situation, is there any remedy that's available to you other than a court application to the, for appointment of a guardianship? Well, there is. Under Section 33 of the Healthcare Consent Act, any child in the scenario may make an application to the board to be appointed a representative of their mother with respect to the treatment. So there's that option available to any child. And of course, if one child applies, what do you think the others are going to do? They're going to apply as well. So that doesn't help us too much so far, but let's go on a little bit, and maybe once you understand the law, you might be able to get creative a little bit. The parties to the application are the incapable person, the proposed representative, all children, the brothers and sisters of the mother, if any are living, and the health practitioner proposing the treatment. So essentially, you've got the whole clan there. That covers everyone. Of significance is that the board has power in an appointment under this section to get creative itself. The board has authority to authorize the representative to consent on the incapable person's behalf to treatment of any kind, not just the treatment that's proposed at this point, but to treatment of any kind whenever a health practitioner proposing a treatment finds that the incapable person is incapable with respect to it. And essentially, that's the same as court-appointed guardianship of the person. Essentially the same when it comes to treatment. The problem is, when you get competing applications, the board may not be able to say that any one child may be a better substitute decision maker than the other. In that case, the board is not obligated to appoint anyone, and it can in fact say that we're not going to appoint anyone, in which case the public guardian and trustee will make the decision. When I was sitting on the board hearing cases of this nature, I would open the proceedings by explaining this to the parties, and usually the competing parties, telling them that I may not be any better than anyone else in deciding whether you're a good son or daughter, you're a good son or daughter, you're the best one to make decisions, and that ultimately at the end of the day, I may not be able to appoint anyone because I simply won't be able to say that, yes, it'd be preferable for your mother to have you make the decisions rather than this person. But I'd also tell them that we all know that going through life, there's emotional issues which children carry, there's matters of trust which may be at play, there may be so many things at play. I'd let them know that my powers in sitting on the board, and board's powers today, aren't restricted to just appointing them or not appointing them. Because if you look at Section 33(7) of the Healthcare Consent Act, the board has power to appoint a representative different from the one named in the application. It has the power to limit the duration of the appointment and impose conditions on the appointment. So in many cases, which I would hear, I would say perhaps knowing what you know that I might not be able to decide this issue, perhaps there's someone who all of you could agree upon, maybe a grandchild of the incapable person, who all of you trust, and that this person might be able and willing to be a substitute decision maker. So perhaps there's a third person that all of you know, and if that person is willing, then perhaps we can consider appointing them as the representative. And then if you still have issues, we can limit the duration of the appointment. We can try it for a certain amount of time to see how it works. And we can put conditions on it. And I can tell you that in 90% of the cases that came before me hearing them, that was a successful resolution without the parties having to apply to the court for guardianship of their mother in this particular type of scenario. Scenario number 2. This scenario is the same as scenario number 1, except the elderly widow is no longer in a coma. And there's only one child. Once again, the mother's being assessed not capable with respect to a proposed treatment by a health practitioner. The mother does not have a court-appointed guardian, nor does she have a power of attorney for personal care. The health practitioner tells the mother that he's found her not capable with respect to a treatment and that he will be seeking consent from her only child. At this point, the mother tells the physician, whoa, I don't want you going to my daughter. We had a falling out, and I don't want her to be my substitute decision maker. So the question is, does the objection of the mother prevent the physician from relying on the consent of the daughter to the treatment? The answer is no. Notwithstanding the objection of the mother, the physician may rely on that consent. But the further question is, what legal options are available to the mother? Well, the mother has a few legal options. Number one, if you're legal counsel for the mother, you can consider whether the mother has capacity to make a power of attorney for personal care. The mere fact that the mother has been assessed not capable with respect to a proposed treatment does not render her incapable of making a power of attorney for personal care. And that's contained, that statement of law, of course, is contained in Section 47, Sub 2 of the Substitute Decisions Act. So don't forget to address that issue. You might consider whether the mother is capable of making a power of attorney for personal care. And if you don't want to go in that avenue, because you may have some concerns, consider whether or not it would be appropriate for the mother to apply to the Consent and Capacity Board to have someone other than her daughter appointed as a representative. Remember, that's the third highest ranking substitute decision maker. So if you don't go the avenue of a power of attorney for personal care, if you have some concerns about that, then perhaps you get an application into the board, provided the mother has someone, perhaps a good friend, that she would want to make decisions for her and that would be available and willing to make those decisions. In such a case, the board would hear the application within 7 days and give you a decision. So you'd have a decision within 8 days. Might be a preferable route than the power of attorney, certainly preferable than guardianship or anything of that nature. Option number 3, and that's the one that sometimes goes unnoticed, is due to its obvious nature. And that's the one to keep in mind. The mother is always free to apply to the Consent and Capacity Board to review the finding of incapacity. And one of the nice things about being an applicant in the mother's case, if you don't do a lot of work in this area, is that the mother doesn't have to prove anything. The onus is not on the applicant in this case. If the mother applies to the Consent and Capacity Board, it's not up to the mother to prove that she's capable. It's up to the physician who made the finding of incapacity to prove to the board on a civil balance of probabilities that the mother is not capable. In fact, the mother doesn't have to testify. In fact, the mother doesn't have to attend the hearing. So really, what do you have to lose? It's one of those options which perhaps you don't think about, but it could very well be that the attending physician cannot meet the onus. The attending physician cannot establish that the mother's incapable with respect to the proposed treatment, something you should consider. And of course, if the physician can't meet the onus, if they can't establish that the mother's incapable with respect to the proposed treatment, there's the presumption of capacity which prevails. And the mother will make her own decisions regarding the treatment. Okay, scenario number 3. Scenario number 3, again, very similar to our prior scenario. However, in this case, the mother's back in a coma. Things haven't been going too well. Still has one child, no power of attorney for personal care, no court-appointed guardian of the person. In this scenario, the child refuses to consent to the proposed treatment. However, there's a sister of the mother who will consent. The question, of course, is can the physician obtain consent from the sister and bypass the child? Well, we know from the hierarchy that the physician can't do that. But what if the physician believes that the child is not capable? Well, in a situation where a substitute decision maker is not capable, it's obvious and it's contrary to law to rely upon a person who's incapable making a decision, to rely on them to make a decision for another incapable person. So the law is quite clear. A substitute decision maker has to be capable. But what's not clear at times is whether the opinion of the physician proposing the treatment and obtaining substitute consent is really saying that the substitute decision maker is not capable, or whether they're saying, well, you simply disagree with me, therefore you must be incapable. So if there's an issue there as to whether or not the substitute decision maker has capacity, what do you do if they come to you? They might ask you, is there an application which I can make to the court? And you would say, well, of course there is. We can apply to the court to have you appointed guardian of your mother, and we can spend a lot of money, a lot of time. But what about an application to the Consent and Capacity Board? Can't the substitute decision maker apply to the Consent and Capacity Board to review the finding that she's not capable of making a decision for her incapable mother? Well, the answer to the question is no, there's no such application. But there's another application which essentially accomplishes the same thing. You can tell the mother, we can get a decision for you within 8 days, maybe sooner. We'll send off an application to the Consent and Capacity Board to have you appointed as the representative for your mother. It's a Form C application under the Healthcare Consent Act. One of the criteria that the board has to consider is whether or not the child is capable. So you'll have a quick resolution to the dilemma you were faced with, the dilemma that the child was faced with, by applying to the Consent and Capacity Board and avoiding guardianship. Next question is, what if in the same scenario the physician was not prepared to say that the child was incapable, but simply saying, well, I don't think the child's making a decision in the best interest of their mother? Is there any advice you can apply to the, or provide to the attending physician, other than, well, simply bypass her and say that she's not capable? Well, we've heard talk today about the Form G application in the Scardoni case, the Cullity decision, and that was a Form G application that went before the board. That's the situation where a physician can apply to the board to determine whether or not the substitute decision maker is complying with the principles set out in Section 21 of the Healthcare Consent Act, which we now know as to whether they've been complying with those and making decisions for their mother. The board hears that application, it renders a decision, and you either live with it or, as I indicated before, you always have the benefit of an appeal. If the board determines that the child has not complied and there's no appeal, then the child must comply, must obey the order of the board. And if the child doesn't comply, they are no longer considered to be a substitute decision maker, and ultimately it may go to the public guardian and trustee, and the public guardian and trustee has to comply. Okay? So the last scenario, scenario number 4. In this final scenario, the mother's out of the coma, but unfortunately she's had a stroke, leaving her incapable of caring for herself at home. She's been assessed not capable of making her own decisions regarding admission to a nursing home. She still has the one child, but in this case, the child has a power of attorney for personal care. Some may think, well, that's wonderful. But in this case, it may prove otherwise. The child consents to their mother's admission to the nursing home and provides the power of attorney to the nursing home. And as you may be aware, there's an agency called Community Care Access Center. This is the agency that authorizes admission to long-term care facilities, i.e. nursing homes. That's who you submit the application to. Unknown to the child, however, the power of attorney which was submitted to the nursing home, Community Care Access Center, which was signed by the mother, contained the following clause: I never want to be admitted to a nursing home. I only want to be cared for in my home. Based on that, do you think the nursing home would authorize the admission? I can tell you they won't. They won't authorize the admission. I've had cases where they won't authorize the admission. They simply won't because of that statement. So now you're in a dilemma. If, of course, you're representing the child. The child believes she's doing the right thing for her mother, wants her admitted to the nursing home. Could very well be the right thing, but we know the law deals with certain legal principles, and one of those legal principles is prior capable wishes prevail. The question is, do they always? Is there any legal remedy for the child short of an application to the court for directions? We all know about an application to the court for directions authorized specifically in relation to a power of attorney under the Substitute Decisions Act. Again, costs money, paper intensive. There's a lot of drawbacks to it. What about 2 applications to the Consent and Capacity Board? The first application is an application to the board for directions. You don't have to go to the court for directions. There's an application here that you can bring to the board for directions. It's a Form D application, and it's authorized under Section 52(1) of the Act. And the applicant, the child in this case, may argue a number of things. She may say, well, the wish isn't clear. It's not clear whether the wish is applicable to the circumstances, or it's not clear whether the wish was expressed while my mother, in fact, was capable. Good luck in the last one where it talks about the wish was expressed. It's not clear whether my mother was 16 years of age. You're not going to win on that one. So if the board agrees with you, if you're persuasive enough, they might say, yeah, we'll agree that maybe the wish isn't that clear. In which case, they'll allow best interest to come into play, and they'll give you some directions on that. But keep in mind, if you fail on that one, there's another one that you can bring in the alternative. And that's a Form E application under the Healthcare Consent Act as well. In that type of an application, the board may give the substitute decision maker permission to consent to the admission despite a wish they feel is a prior capable wish if it is satisfied that the likely result of the admission would be significantly better than would have been anticipated in comparable circumstances at the time the wish was expressed. An extremely challenging application. The board must put itself in the position of the incapable person and on all of the evidence before it make a decision that the mother would now consent to the admission because the likely result of her admission now to a nursing home is significantly better than when she expressed her prior capable wish never to be admitted. So in conclusion, just when you thought prior capable wish has always prevailed and there'd be no hope, keep in mind what I call the faint hope application. which is the Form E application to the Consent and Capacity Board. Thank you very much.
If our next panelists would please come forward, Ian Hull, Marshall Swadron, and Joe Wright. And let me just add to what Darcy had to say. I see in practice numerous cases where people have initiated guardianship applications that probably were unnecessary, or where a completely satisfactory remedy could have been obtained with a lot less cost and fuss by way of an application to the board. And the other consideration that I'd like to advance to you is that the relative informality of the board often makes it a better venue in which to approach the resolution of the sorts of cases that Darcy outlined in his scenarios. Let me then proceed to introduce our next three speakers in the order in which they're going to speak. I assume you'll all speak from the...
Yeah,
You want to speak from the podium?
that's okay.
Sure. So our first speaker, let me introduce everyone, Ian. Our first speaker is Ian Hull, who's extremely well known as an estates litigator, a prolific author of books and papers, an editor of the Estates and Trust Report, and an all-around swell guy, although not as good a skier as he thinks he is. To your right is Marshall Swadron. Marshall, also extremely well known for the work that he's done in the general, actually in all the domains that we're discussing here today, as counsel in mundane cases and in high-profile cases. Marshall's appeared at all levels of the Ontario courts, the federal court, and he's appeared in the Supreme Court of Canada. He also has considerable experience on both the civil and criminal sides in representing people alleged to be incapable in one respect or another. He's a member of the Advocate Society, the Toronto Lawyers Association, and the Mental Health Legal Committee. And finally, in the middle, we have Joe Wright, who I've known from the beginning of my career, although he may not remember that, who is here today, I guess, in his capacity as legal counsel to the Ontario Review Board. He is a criminal practitioner. In addition to providing advice to the Ontario Review Board, he's also a private practitioner in the area of criminal law, and he brings to the panel a wealth of experience in the area. Ian, will you lead off, please?
Sure. Well, thank you very much, Arthur, and I will today attempt to talk a little bit about the deemed capacity to act under the Substitute Decisions Act. We're sort of going to break it up into three sort of mini comments and then open up to the more panel discussions. I'm always intrigued when I hear Darcy speak. He's without a doubt a leader in the area in terms of the board work that he's done over the years, but I was more encouraged by the fact that there's a faint hope application in that realm of the world, because I sort of feel like when I'm in the SDA world, I'm almost always going before the court with a lot of faint hope that the judge will actually consider it and listen to it and want to deal with us. And I say that in jest, but also with the reality that in the sphere that I'm mostly in, and although I do the board hearings from time to time in the courts, I'm there because it is typically incredibly contentious, and this is what they're paid the big bucks for. They're going to have to decide who the appropriate guardian of property or personal care is going to be. You don't always get into fights over personal care, but you can also spend a lot of time and emotional energy, the family and so forth, in personal care fights just as much as you can over the property. So the one angle I just want to make some comment on was this idea of Section 3 counsel under the Substitute Decisions Act and the whole question of deemed capacity to act. With the SDA I always go to the SDA directly whenever I'm sort of asked to consider something in the context of that litigation, because the Act itself is remarkably well written in my view, certainly compared to things like the provisions under the Succession Law Reform Act when you get into some dicey language. This Act tends to at least send clear messages. And I start with what is really Section 3 of Council. This whole issue in deemed capacity is pretty well the ultimate gray area when you're dealing with contentious proceedings such as fights over guardianship. And if you look at the section and you look at the provisions, it deals with the appointment of counsel for a person whose capacity is an issue in a proceeding under the SDA. So you want to make sure you're not trying to bring this into other spheres. The Act expressly says where you're supposed to work from. And as I say, in a faint hope type of application in typically a contentious environment where the alleged incapable has no counsel. An obvious example that we run into in the courts is a situation where two different children are fighting over the control and custody of their aging adult parent or parents, and that parent or parents have no counsel. And there is some question as to capacity, and that as the Act says, and Section 3 expressly says, is that it is to be applied where counsel for the person whose capacity is an issue. I want to make a couple of comments later about Section 79 and how that dovetails into how we deal with it, but looking at Section 3 and looking at the power of the court when they will appoint counsel in this situation pursuant to Section 3, the court may direct the public guardian or trustee to arrange for legal representation for the person. And the section goes on, and the person is deemed to have capacity to retain and instruct. So once you get your Section 3 appointment, it doesn't mean that it's all over and that you can move forward with some clarity and some certainty because of the specific express language under the Act. We have to be very careful. So what does it mean? It is always a good question. It's a relatively new provision. It's a gray area of the law. I can tell you the judges are universally terrified to deal with it in terms of wanting to step into what are extensive, intrusive steps into people's lives. So you've got that environment. You've got counsel on both sides. You've got all sorts of outrageous costs being thrown at it. So what's the answer, and what does Section 3 mean? Well, as we heard this morning, and we'll hear again and again, no doubt, is if in doubt, go to a judgment of Justice Cullity. So we're going to do that. Because Justice Cullity in Banton versus Banton, I think, gives us what is at least some really strong guidance and some useful guidance as to how we deal with this issue of the appointment of Section 3 counsel and what their role is. He comes at it from the other end, and which is, as he can only do, a fascinating way of teaching us. But the facts in Banton are good fun in the sense that they're as remarkable as you'd want in a contested litigation environment. The deceased was married 3 times. His first wife had 5 children. The family dynamics are what you can expect. The deceased, George, got friendly with a caregiver at his retirement home late in life, and without getting into all of the details, the caregiver eventually married George, and all sorts of interesting estate planning techniques were employed over the period of time of dispute. And this dispute was what a classic SDA environment is, and that is that the children are seeing their parents being pulled by one or more people that they don't necessarily trust, and financial decisions in this case are being made in the context of that. So with that friendly and happy environment, eventually, as I say, the deceased does get remarried and passes away, and a will challenge comes in. It's always easier for us who do the estate litigation once they've passed away, because the power of attorney litigation is what I call the most contentious and most expensive and least result-oriented litigation you can ever get into. Will challenge, at least you've got a fixed moment in time, the person's not alive, and we get into some of the juicy questions like undue influence and things like that. In this case, in the Banton case, what was so important here was undue influence was being obviously alleged in a very meaningful way. And so Cullity said in the decision, he said, well, look, I want evidence. I need to hear the evidence from Section 3 counsel who was appointed for George in this whole melee of estate planning and marriage and setting aside and power of attorney fight, all of this period of time where it's alleged that George was maybe was certainly mentally frail. Was he incapable? Was he not? All of that sort of stuff. So Cullity looks at that particular counsel who was appointed and puts a microscope on that counsel and says, okay, what did you do and what can you help me in my undue influence case? Again, we may wonder what do we care about that in the context of deemed capacity under Section 3? Well, Cullity, what I think does is give us some good background and teaching on how he sees Section 3 counsel should have acted through this period of time once appointed under the Act. And when testing undue influence, the court needs corroborative evidence. So if you're going to be appointed Section 3 counsel, you can, not only are you're subject to some criticism down the road, you're also going to be likely a witness in the will challenge proceedings. So in this case, in Banton, the witness was brought to task. So what does Cullity observe? And I just want to summarize those quickly. The key in Cullity's mind in this decision is, Justice Cullity's mind is number one is, and it's an obvious and it's a bit trite, but it's something that is comforting to any of us who've been appointed Section 3 counsel, and that is he makes it perfectly clear that appointing anyone appointed Section 3 counsel under the SDA has a very tough job. And while it is trite, it's also important to remind the courts of that reality, because the practical reality is once you get into the job, it can be unbearably difficult. Then he goes on to comparing Section 3 counsel appointments under the SDA to that of a litigation guardian. The natural sort of extension that before the Banton decision came out, I had seen certainly submissions made, and some people considered that once you were appointed Section 3 counsel, you were the litigation guardian in effect, and there was this kind of feeling. Well, he, as he quite properly should have, made the point that it is very different than litigation guardian. You are not being appointed litigation guardian in any sense of the word. You are not given authority to make decisions in the best interest of the client, as the litigation guardian is compelled to do under the rules. The key is that Section 3 counsel must take instructions. They must not act if he or she is satisfied the client does not have capacity to instruct. So you're always going to be put to the test of whether or not you were acting on behalf of a client who could and did have capacity to instruct, and that's an issue that's always ongoing. In Banton, Justice Cullity looked at the conduct of the Justice Section 3 counsel and said that he had some trouble with Section 3 counsel's evidence because he didn't really believe that that counsel's antenna was up sufficiently in respect of questions of undue influence. And so I add that to my list. If you're into that framework, you are going to be put under the microscope. Undue influence is a primary issue in terms of who's influencing your client outside of the courtroom environment. In this case, the relationship between the deceased, and this was a caregiver in the facility where she lived, and the court was carefully scrutinized. So what Justice Cullity did was he created a do not do list. And he said, first of all, don't let the caregiver convey most of the instructions by telephone as was done. Don't let the caregiver and eventually wife be the deceased's mouthpiece. Make sure the dockets are fulsome and accurate in their capacity as a Section 3 counsel. Don't let the caregiver or any potential undue influencer directly be involved with proceedings. Don't do things like letting the deceased misspell his grandchildren's names in the affidavits on the basis of evidence from the caregiver then wife. Don't let the caregiver attend all meetings at the signing of the various affidavits. And most importantly, he said, don't show signs of partisanship and aligning yourself with a potential undue influencer. And it's a trap that as Section 3 counsel can get into in a heartbeat, in my view. So the last comment I want to make, just so that we can let the rest of our panel give their introductory comments, the last two comments. The first is that I want to remind people that Section 79 of the Substitute Decisions Act dovetails into this. We'll probably get into this in the roundtable discussions, but the court has the power to order an assessment, a capacity assessment, and it can be a powerful tool in the context of really contentious proceedings. And I've included some precedents that I think help give some guidance in terms of how you would want to proceed in a contentious environment, not the one where we're going to be faced with at the board, where you're able to avoid the difficult question is who's best to act. The last comment is at the end of my paper. I just say the important points to take away with Section 3 council appointments is that they should not be appointed unless it's in the proceedings. The same kinds of concerns with regard to undue influence in respect of preparing a will are usually prevalent. Section 3 council must not be overly partisan, and remember that you don't have the litigation guardian flexibility that you do in such an appointment when you're Section 3 counsel, and you have to take instructions in that context. So I hope that sets the stage for some more comments and some discussion. Thank you very much.
I find, having served as Section 3 counsel myself, that it is a most difficult area, and that any guidance is of assistance. Justice Cullity's guidance is a list of things not to do. I'm still looking for the list of things to do. I'm grateful, of course, to hear anything Ian has to say on anything, but on this subject in particular. I'm looking at the Consent and Capacity Board and the ability to take instructions from a client whose capacity is an issue. And I start with the rules of professional conduct in the paper, and it's a very easy place to start. And it is guidance to tell us that, well, I'll read because the rules do it better than I can. When a client's ability to make decisions is impaired because of minority, mental disability, for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal lawyer and client relationship. So what does that mean before the Consent and Capacity Board? First thing is, especially when the issue before the board is capacity, we do not act as judge and jury. In fact, we are advocates in favor of a finding of capacity, and we are advocates for our clients' wishes, whether our clients are capable or not. And some of the traps that one might fall into are not just as counsel, but as a board or a court, are considering in those steps the issue of best interests. Best interests are the subject matter of other steps in legislation, not to be considered at all when looking at the issue of client instructions. I've set out in the paper 5 principles for client-based advocacy in matters before the board that will help you not only in your relationship with your clients, but ultimately in informing your strategy in dealing with the case, in helping your client, in trying to resolve the problem they have, and then ultimately, of course, before the board. The first is that you should hear from the client first. That means that although you may, as counsel, and one of my roles here might be to answer some of Dr. Chandrasena's questions, but although you might have an entitlement as counsel to a client before the board to go directly to review their records, whether they sign a Form 14 or not, and that's in the Healthcare Consent Act. I think it's subsection 76, sub 2 or 3, but it's there. We have that ability as counsel once that role is established to just go to the record, not even see our client first. That is not a step to take if you want to establish the client's trust. For the client to know that you are their advocate, you must go and see them first, hear the story first from them, and not from a family member, not from a physician. And again, it works because those records will still be there. The physician or family members will still be there. The client's first impression and opportunity to impress you with what it is they'd like to tell you is only going to be there when you see them first, and you could only do it once. Use the opportunity of meeting with the client and hearing their story first to take their wishes and start thinking about creative resolutions that will accommodate what they're looking for, what they want, whether it's exactly what the board can give or not. It's an opportunity to find out what your client wants so that when you look later at settlement discussions or other opportunities to resolve things, that you can try to carry those and out and get them into effect. Next is discuss the substantive issues with the client and be prepared to explain the process. Now, often in a hospital situation, the amount of time that a physician will be able to spend with a client is infinitely smaller than the amount of time that you will have as counsel. Don't be afraid to educate, to explain, to even take on the role of gathering information for the person, providing them with documents about the medications that are proposed, providing them with excerpts from the Diagnostic and Statistical Manual, because if they can use this information, if it's going to be a benefit to them, then they will. It may not have been provided to them, and if someone is involuntarily detained in the hospital, they don't have access to the internet or to a library, you're it. Next is present options and recommendations. This can really happen, only happen most effectively once you've done everything that you can in the case to find out what the case is about. So if you're sort of suggesting options to the client and trying to tell them what it is the first time that what the case is about, the first time you've met them, you're really not going to be giving them an informed opinion. So it might take, it's likely to take a second meeting at least before a hearing. And if there are prospects for a resolution, if there's a chance that things could be resolved short of a hearing before the board, this is the opportunity to discuss that. And if you think that your client's case is going to fail, you can put it to them in a way that is not going to suggest that you don't trust or have faith in them, but it's that the outcome is based on experience and what the board is likely to do. You can sort of put the burden on the board as sometimes not doing the right thing, but in any event, explaining what the likely outcome is without having to say, well, in my opinion, you do have this condition, et cetera. You can at least convey the information without having to offend them in any way. Next is, once you do have instructions, and this is important, it's instruction-based advocacy. It's not what the lawyer thinks is going to be the best way to carry out the outcome. Even if you do get instructions saying that I'd like to get out of the hospital, you still then have to go through the process of having the client make the ultimate decision about how the process is going to be used. So what this sometimes can result in, though, is that a client may give instructions that are inconsistent with what you think is the best route of advocacy. A client may restrict you so far as reviewing the clinical record. A client may restrict you so far as talking to family members or their physician. These are difficult things that sometimes a client will do and that we're bound to carry out. There is no better way to breach a client's trust than to do something that the client has told you not to do. Don't look for these kinds of instructions. Don't at every single stage say, is it okay if I speak with these people, and I'd like your written instructions to make sure you said it was okay. If it's the kind of instructions that sometimes happen where a client has a very particular view of something, and those instructions will come. When it does, do your best to persuade the client of the effect that this will have on their advocacy, and if necessary, document those instructions in writing. Document as well the advice that you gave them, the recommendation that they not pursue that course of action. And again, it's sometimes the step of asking someone to read something that they're telling you to do side by side with the recommendation you're giving them that it's not a good idea causes them to have that second thought, and perhaps if rather than put pen to paper, give you the instructions that allow you to carry through the hearing and do the best job that you can, and that they'd like you to do. Finally, the fifth point is advance the client's case to the fullest extent permitted. Now, we're all advocates, and we know this, and this is second nature. But there are certain things that will have to be done in the course of appearances before the board, that if a lawyer doesn't do them, they won't happen. Someone does not receive rights advice, for example, after they've failed in an application to the Consent and Capacity Board. So it is in an obligation to advocate that continues beyond the decision of the board. A client needs to know what their rights are so far as possible appeals from board's decisions, and that's up to counsel to provide it. And although it would seem to be an extraordinary burden to someone who's just represented for a hearing and not necessarily for an appeal, and who may not even think that an appeal has merit, but the 7-day time period in the legislation for an appeal more or less makes it necessary that if the client says that they'd like to appeal, to take the step to preserve the appeal right and to bring the appeal in their own name. And again, it's simply part of the role that you fall into when you are the only person there that could help them with a very short period of time to appeal. What I did in the second part of the paper is that I took what I'll call a top 6 list, because I don't need 10. Letterman's got nothing on me. The first is that often you're confronted with a situation where your client can only express basic wishes. And those are, I'd like to get out of the hospital, I don't want the medication. Those are relatively straightforward cases, and that it is, if that's all the client articulates, it's still enough to go on. You can certainly accept those as instructions. A little more difficult is the twist where the client gives no instructions. This may happen in circumstances where counsel is appointed, or in circumstances where, as we've discussed earlier today, end-of-life decisions where someone is unconscious. What your role there as an advocate is to ensure that the legislation is fulfilled. You can also do some investigation to make sure if a prior wish has been expressed and it is applicable to the situation, and it's a capable wish, of course, that wish be carried into effect. So you have the opportunity to get that information before the board, and that's a role that you can pursue. Next is a situation where a client refuses to meet with you. Well, deemed capacity to instruct, or actual capacity to instruct, includes the capacity to discharge counsel. So there is relatively little that counsel can do. Often you have to take a step just to make sure that those are the client's real instructions and that they're not being placed under any pressure to withdraw the application. Once you've met with your client and you've obtained the written instructions, again, to withdraw from the case, then you inform the board and you simply withdraw from the case. The next point is representation orders under the Healthcare Consent Act, and it sort of dovetails together with the question of, well, if I'm not actually hired by this client, why, and I'm in fact appointed by the public guardian and trustee pursuant to the board's order, what happens if the client still wants to represent themselves or wants to discharge me? I think that in that situation there are some developments that are taking place, and unfortunately there's some uncertainty as well, as always happens when things aren't static. But it would appear that the client's ability, when they're deemed capable of instructing counsel, even when counsel is appointed for them, to terminate that counsel is probably still there. Then the next question is, well, what do you do when the person is wishing to advocate for themselves, not necessarily adverse to a lawyer being there and taking a position that supports them, but their main reason for not wanting to have a lawyer is because they wish to advocate for themselves? Well, in this situation is an opportunity for counsel to act as amicus, amicus curiae in the case of courts, or we'll just call it friend of the board in this case. And there have been situations recently where counsel, on the agreement of all parties, have served the role of a friend of the board. That is an excellent development in my view, because it allows the client's voice not to be overtaken by that of counsel, but ensures that the legal arguments are still made. I was involved as amicus in the Court of Appeal recently in a case that I've cited in the paper where it was almost before the Court of Appeal as to whether this was an appropriate response. And what happened was that the hearing didn't take place. However, we do have the Court of Appeals decision in respect of the ORB proceedings in Professor Starson's case over the last year, in which the Court of Appeal has endorsed the use of counsel appointed for Professor Starson and, as amicus, while Professor Starson represented himself. Okay, I'm going to leave till afterward the question that Dr. Chandrasena raised regarding what happens when the lawyers had access to the chart and the client is not entitled or is not permitted access to the same information. We could perhaps deal with that on the panel. I've discussed the issue of confidentiality in the paper, and then finally the issue of getting paid. I felt that it was safe for me to avoid touching that in the discussion because those who are interested in getting paid for this work will probably read that part very carefully on their own. Finally, I just wanted to indicate that this area of practice is thoroughly rewarding. It's if not necessarily financially rewarding, it is an excellent, a tremendous opportunity to advocate for a most deserving clientele. Thank you.
I'm going to refer to part 20.1, and my materials are at tab 13, I think. Part 20.1 is a discrete part of the criminal code, recently referred by the Supreme Court of Canada as a unique scheme within the criminal process. And it replaced the old and I like to think archaic provisions, mental health provisions, mental disorder provisions that existed up until 1992. And I think most people would agree that they are a modern, fair, and compassionate way to deal with people who have mental disorders who become caught in the criminal justice system. The new provisions, of course, came as a result of a case called Swain, which struck down the existing insanity provisions, as they were referred to then. And the decision sought to place mentally disordered accused persons on a level playing field. And as a result, we have Part 20.1. How do you get to Part 20.1? I guess first and foremost, your client is arrested. If your client is not released from a police station on a promise to appear or an undertaking, they have to make a first appearance in custody. From that juncture on, Part 20.1 as a comprehensive scheme can take over. If there is a question about your client's fitness to stand trial at that juncture, there are assessment provisions there. If your client's capacity or fitness to stand trial is equivocal, if I can put it that way, it's likely that the person is going to be sent to a hospital for a 30-day assessment and come back. If they are found fit on return, they proceed through the system in the normal course. If not, one of the other provisions allows for the Crown to apply for a treatment order, and it's kind of unique both in mental health legislation and the criminal code. This is the only juncture at which the Crown can apply to have treatment forced on an accused person. You'll see the criteria at 672.58 of the criminal code, and you can read that for yourself. Again, in my experience, most people who are subject to treatment orders do come back as fit to stand trial. And again, the presumption of regularity, if I can put it that way, operates, and counsel can For one thing, particularly if they find themselves in a mental health friendly court or in the case of Old City Hall's 102 court, decide whether their client's matter might be considered for mental health diversion, and I think we're going to talk about that a little bit later, so I won't go into that particularly. At that juncture, you might also, as counsel for an accused, look at the not criminally responsible provisions. Now, although those provisions are referred to as a defense, I think a lot of counsel would not really refer to it as a defense. They might refer to it as a trap, and I think it's something that you'll really want to look at and think about carefully before you decide whether that's a road that your client should go down, and you'll really want to think about that before you sit down with your client and go into the ins and outs of what that involves. Those sections that refer to dealings in court, I refer to as the front half of 20.1. Conceptually, there are discrete sections that apply to all the way through the process while you're in court or when you go on and become under the jurisdiction of the review board. But for the moment, I'm just going to refer to the back half of 20.1, which starts to operate when your client comes under the jurisdiction of the Ontario Review Board. I'm not sure how many people here have done Ontario Review Board hearings. I'm just going to talk a little bit about what they're like. The code indicates that they're supposed to be informal hearings, and although there's obviously a lot at stake for your client, I think by and large the proceedings are informal. I think review board members try to make the proceedings user-friendly. In my experience, they try to make counsel, and particularly the client or the accused, relaxed so that everybody can proceed and the best information and the best decision can be made. The board's proceedings are subject to rules, and I'm grateful to Dan Brodsky, who has included in his materials a section of the rules, also a copy of Part 20.1, and also some leading decisions that I've referred to in my materials that you can look at on your own. The proceedings, the Supreme Court of Canada has indicated, are not adversarial. I'm not sure everyone would agree with that, but the court has indicated that the process is inquisitorial. And I think that's true particularly when you glimpse, for example, the dual status provisions, just as an indicator. A dual status accused before the review board is somebody that is both detained in a hospital pursuant to an Ontario Review Board disposition and subject to a sentence of incarceration at the same time. What's interesting is, and conceptually the point I'm trying to make is, it is not a court that decides where that person is to be placed, it's the review board. So even somebody that's serving a life sentence or may be considered to be a dangerous offender in court is placed by the Ontario Review Board, and it's the review board pursuant to a placement decision that decides whether that person is to be detained in a jail or in a hospital. At those hearings, the evidence usually consists of a hospital report and any other evidence that parties want to bring. Quite often that may be evidence from a family member, a report from a social worker or a mental health professional in the community, something from a family doctor. The Crown may tender similar documents, incidents reports that may have not led to criminal charges. It's interesting to note, and everybody should be aware, that the accused is not a compellable witness at these proceedings. So quite typically, proceedings proceed without the accused person saying anything. I was grateful to Dr. Chalasendra earlier, going into the ins and outs of medical charts, I would always urge council to go to the chart and find whatever information is of interest to them there. Certainly, I think it's very common, and I think Suzan Fraser would adopt the idea that there's often information in the chart that would indicate that the hospital's position is contradicted in some respects, not supported, or there's other information there that would be of interest to you as council. Quite often the issue is simply what disposition the board's going to make with respect to your client. There's only 3. They're found at 672.54. That's an absolute discharge. If the state is not able to show that a person is a significant risk, that person is entitled to an absolute discharge. And although formerly that wasn't available to people that were unfit to stand trial, now pursuant to the case of R versus Demers, you're going to be able to ask for an absolute discharge or a stay if that legislation isn't amended in the next, I guess, about 8 months. Second disposition that can be made is a conditional discharge. Conceptually, I always had difficulty with this, and I think now I understand that a conditional discharge is granted to somebody that the board can't conclude is a significant risk, or if the board is not able to conclude that that person is not a significant risk. And that person typically will be considered to be on their way out of the system. They will be living in the community with some conditions, and their council will be trying to decide when it is that they're going to be entitled to an absolute discharge. The third category is detained in a hospital, 54C. If the person is a significant risk, and that if and only if that person is considered to be a significant risk, can they be detained in a hospital. And of course, there is a panoply of conditions that can attach to a disposition order or a detention order, up to and including living in the community. It's quite typical that somebody is detained in a hospital but living in the community. In my materials, there is a sample disposition and a sample set of reasons. And if you haven't done a review board hearing, you can look at those materials, and I think it's fair to say that you can pick up a lot of the issue and what is at stake at any given hearing by osmosis. I think I would indicate that it's always a good idea for council to pick what their issue is and focus on that issue. If you've got an hour to cross-examine a doctor, you might as well put all your eggs in one basket and cross-examine that doctor about significant risk if that's what your particular issue is. There is a hospital report. I think you can safely assume that all the board members have read the hospital report, so that you don't have to spend time going over that. You can select the discrete issues that you may be interested in. And again, I'm grateful to Dr. Chandrasena and his deconstruction of a medical chart. I think that'll be of use to everybody. I should indicate as well that the ORB has a website. It's www.orb.on.ca, and there is a history of Part 20.1 and the review board there that's quite useful. Just some practical matters. All orders and decisions of the review board since 2000 are public, and they are available on Quick Law and I think elsewhere. I've been told that some of the reporting is a bit spotty. Some institutions or some places are better than others about reporting their decisions. Legal aid. In the Toronto area, council should understand that if you're granted a criminal certificate, the initial hearing is automatic. In other words, if your client is found NCR or unfit and you have to attend a hearing before the ORB, you're automatically covered. I think in Toronto as well, the Toronto office is fairly flexible about granting legal aid certificates, whereas some other areas of the province are not. I think some areas of the province take a very unforgiving look. If somebody has a discretionary income that's marginally out of line according to legal aid, they'll refuse coverage. I don't think you'll find that in the Toronto area, and I believe that legal aid is now working on a policy that may apply provincially. If you're dealing with an area office that is reluctant to provide legal aid coverage, I would encourage you to ask them to speak to the headquarters at 375 University or speak to them themselves, because as far as I'm concerned, this is the core demographic of legal aid, and unless a real discrete reason can be shown, that person should be granted coverage. I should indicate as well that under the terms of the ORB's legislation, they are also able to appoint counsel. In the case of unfit accused, it's mandatory, and in the case of NCR accused, where the interests of justice require it. And I'll just conclude by saying board hearings are becoming more complex, drawn out. The issues are becoming more complicated, and more I think it's necessary for the board to have counsel, and I would encourage you to write to the board if your client isn't approved for legal aid coverage, and ask if the board would consider appointing counsel.
Thank you, Joe. Thank you to all three panelists, and thank you also for sticking to the schedule so that we've got ample time, not ample time, but at least time left for questions. Let me start by, are there any questions in the audience?
I have a question arising out of Darcy Hiltz's scenario 4, but he or Mark might be able to answer. How does mom get counsel to argue she shouldn't have to go into the nursing home?
Okay, let me just repeat the question so that everyone can hear it. So arising out of one of the scenarios presented earlier by Darcy Hiltz, where you have an elderly, vulnerable person and presumably in hospital, and someone has proposed that she be admitted to a care facility and she doesn't want to go, how does she obtain counsel? Marshall, do you want to field it, or?
Sure. One of the difficulties with that particular decision, where someone is found incapable of making a decision about admission into a nursing home, is that there is no provision for rights advice. And what has to happen is you have to have someone proactive somewhere who's prepared to bring forward the fact that someone doesn't want to go into a nursing home and they're headed in that direction. One organization that does tremendous work in this area is ACE, and it happens, or Advocacy Center for the Elderly. It's probably not known by that anymore. It's just plain ACE. What often happens is that a family member or someone who is concerned that someone is sort of heading on a one-way train without anyone asking questions about it will get in touch with that organization or otherwise locate counsel. You have to have someone intervening that's well-intentioned to get that information out.
We have lots of experienced counsel in the room. Does anybody want to add anything to? Next question.
Yeah, this question is directed to Darcy Hiltz. Let's say, I'm just trying to get something clear about these applications. Let's say week 1, the treatment is that Granny's supposed to get a breathing tube put in, and it ends up going before the board. And the decision is the child can make the decision. Then next week, Granny's supposed to get a chest tube put in. Does that mean a whole other board hearing?
So let me, could everyone hear I'm looking at the back for some help. Everyone could hear. Darcy, we've got a microphone here if you want, or See how provocative you are?
One would think that perhaps that might be a plan of treatment, but certainly if it's a treatment as defined by the Act as not ancillary to the first treatment, then certainly one would expect, since it would be considered a different treatment, that consent would be obtained, and if there was no consent provided, and the mother wished to challenge that, then the mother could challenge that. If the mother didn't challenge that, then of course the substitute decision maker could consent to it. But it's a question of whether it's part of the plan of treatment, which was initially put before the board, or whether it wasn't part of a plan of treatment, and it's now considered not an ancillary treatment, but a different treatment.
Play Phil Donahue over here. I think what I'm going to do is ask Joe first, if maybe you'd provide just a brief introduction to the order that our questioner is talking about so that everyone's up to speed, and then
To be under the jurisdiction of the Ontario Review Board, there would have to be a verdict in court, which would be NCR or unfit. The court might or might not make an order. In any event, the review board has to see that person within 45 or 90 days. They would make a disposition, and essentially they would, in your scenario, the person's detained in a hospital, I take it, they would make an order detailing the conditions and privileges that that person would be entitled to for presumptively the next year. Treatment is not a particular, although the board is always interested in details of treatment, I don't think they enter into treatment decisions. That person, that person doesn't have to take medication, for example, unless they've been told by some other scheme that well, I'm going to get Marshall.
One sec, please, because I've just been reminded that although people in the room may be able to hear the question, our remote participants through the BarX program can't. So let me translate, and I'm going to edit, if you don't mind. And let's turn it into a general question, and that is, it sounded to me the second time you presented the issue as though it's as much a factual problem as a legal one, and it's one that also arose in the Starson case. and that is where patient is essentially told whether you're detained pursuant to the provisions of the criminal code, or you're being held, or your liberty is being deprived of liberty in some sense pursuant to the Mental Health Act, because you are being told either you take treatment X or the following result will ensue. And client is saying it's not that I'm resistant to treatment, but rather that I'm resistant to treatment X, and what I would really like to have happen is to sit down with my physician and canvass the array of alternative treatments, and among other things, ensure that my particular concerns about the particular side effects or consequences for me that I'm going to suffer are adequately taken account of. So, and I put it in that way deliberately to broaden the scope of the discussion and invite whoever would like to participate in answering to do so. Marshall, would you like to take a stab at it? And then Dan?
The first thing is that this is a general healthcare consent issue, because the authority for the treatment is not from the Ontario Review Board. It's because, in fact, the Ontario Review Board cannot, absent consent from from the person who would receive the treatment, make an order for treatment. The remedy for this person would seem to be an application to the Consent and Capacity Board to either establish that they are in fact capable of making their own treatment decisions, or if it is has reached the point where there's no communication between patient and physician, and an advocate is sort of stuck in the middle, it looks like the only way to resolve that kind of loggerhead problem would be to look at the next annual ORB hearing and ask for a transfer. That kind of communication has to happen. It can't be either you take these medications or you have to stay in hospital, where the medications defeat the purpose for being out of hospital.
Well, let's see what, I know Dan, I'm going to ask you, Dan Brodsky, if you wouldn't mind coming over and taking the microphone, otherwise the remote participants won't be able to hear you.
Certainly. There's actually a short-term practical solution to some of these problems. This is not a problem that doesn't come up. It's not a problem that doesn't happen very often in some other provinces. In Manitoba, I'm litigating this issue in a case called Earl Joey Wiebe. There was no problem. The jury had absolutely no difficulty determining that Mr. Wiebe, who was a cannibal, well, the doctor didn't believe he was a cannibal despite the fact that his wife's liver was on the stove and the rest of her was in the bathtub for some weeks before the neighbors complained. The jury, it was the first time, my father's a lawyer in Manitoba and he's done about 600 murder trials. It was the first time he'd ever had a jury trial where the jury didn't leave the room. They found him in NCR after the judge told them they can go deliberate in about 15 seconds. Difficulty is in a small province like Manitoba, the doctors who come to testify in court, they come from the local hospital. So the doctor's already committed in court to a position, this guy's not sick, he may have a particular eating disorder, but we're not going to treat him. The difficulty with that is 3 doctors from Ontario came to testify that not only is he ill, but he will be, it's their hypothesis that he'll be responsive to a certain kind of treatment. So he's had his review board hearing. The review board of Manitoba has ordered that he can go to Ontario. Manitoba Attorney General is prepared to drive him to the border. The hospital here at Penetang is prepared to accept him, but our Attorney General has denied having him come to Ontario because, well, he may respond and then he may get out of Penetang and he may decide to take up residence in Ontario. The point is the transfers may or may not work. The issue that's being raised in Wiebe is whether the Crown has any business having a veto power over the availability of treatment. But the short-term answer, long-winded as it is to take the matter to the college. If there are alternative treatments available that the treating physician is not prepared to consider or involve himself in, and since the client can't fire the doctor, involve the College of Physicians and Surgeons.
Marshall, let me ask you, because you did mention that at the second meeting with the client, you'll often use that as an opportunity to fully canvass options, including the possibility of a resolution short of a hearing. And you also mentioned that you actually provide clients with extracts from the Diagnostic and Statistical Manual or other helpful materials. Is this something that's come up in your practice, and have you found that it's something that's open to negotiation, or that you've been able to raise with physicians in the civil context?
Some issues are more difficult to negotiate than others. The capacity is either there or it's not there, so it's hard to have treatment take place on the basis of deemed or agreed capacity. But in respective cases involving involuntary status or community treatment orders, it may be a particular aspect of hospitalization or the community treatment order that is objected to, or the duration of hospitalization. These things can be resolved. Many cases do go to hearings. In fact, the majority do, but some can certainly be resolved.
One last question, and then we're going to break for coffee. So again, just because we've got people who aren't in the room but participating, so we've got counsel who's conducting a fair number of hearings, and I assume that these are hearings under the Healthcare Consent Act with respect to capacity to consent to treatment, and you're finding that you're losing many more of these cases than you win, and I guess that the question is, what can counsel realistically expect in terms of taking that particular issue on? I don't know what the board statistics are, but Marshall?
I do know them. The average over the last 5 years I worked out to be about 6.5%. So in your next 10 hearings, you'll succeed in one. The difficulty is that it's either the legislation is being used very well by physicians, or the test is a very difficult one to overcome. What I've found is also, in terms of statistics, is that it varied very much depending on where you lived in the province. You had a dramatically higher likelihood of being found capable in Hamilton than in Ottawa or Penetanguishene, for example. So I think that that the answer is that every single case is an opportunity and a new set of facts, and you have to make the most of that opportunity. And if there was an easy way to sort of change the numbers, it certainly wasn't the Starson case. In the period of time after the Starson decision came down, the numbers actually fell down a couple of points in terms of provincial average. So I mean the Starson case at trial, or at the first level of appeal, I should say, rather than at the Court of Appeal or Supreme Court of Canada. So it's a mystery.
Okay, sorry, we're going to take, so did you have a question?
I just have one question which I thought was left, which is whether Marshall's comments are applicable to an individual representing somebody before the board, just on that question of capacity. So if you're dealing with a fitness hearing or an NCR hearing, is the approach to capacity the same if you don't have instructions? What's your role?
Okay, so Marshall, again, we did ask Marshall specifically to comment on the issue of deemed capacity to instruct in the civil context on the Healthcare Consent Act and Mental Health Act side of the coin. But Sue Fraser's now asking you, I guess, are those rules applicable to the criminal code side, and does the same approach in general apply? I know that you act on that side of the coin as well, so I feel it's a fair question to pose to you. And even if it's an unfair one, I'm going to do it.
I'm happy to try. The deemed capacity in the context of the kind of request that you're going to make. If you're going to ask for an absolute discharge in circumstances where it's unreasonable, but that's what the client asks you to do, that's what you're going to do. You can do well to address the more realistic terms or conditions that are being considered by the board, and make sure that you comment and speak to those. But there is no substitute for actually listening to your client and asking for what they ask you to do. I can't. I think that if there is a situation where a client is not giving any instructions, that it is simply a question of making sure that the statutory provisions in the criminal code are met. So I think a lot of the things that apply before the Consent and Capacity Board will still apply.
This is one of those topics that, this alone, I think, is probably a subject for a day's worth of discussion. And I want to thank all three of our panelists for tackling this particularly naughty area. This is our gray zone, I think, and you've done a wonderful job in some instances of providing answers, and where the answers aren't available, at least of opening up the basic rules and the considerations that council ought to be taking account of. And please join me in thanking all of them before we break. We'll reconvene in 10 minutes.